Hello, my dear friends. My name is Alexander Dozdov. I'm professor, doctor of science at Yaroslav Multinational University, and representative our articles with co-authors Pashkovsky, Glinskaya, Klepka, Gavrilenko, and I. Investigation of cyber attacks in the context of the armed conflict caused by Russian aggression against Ukraine. Next slide, please. A few words about introduction. According to the Ministry of Defense of Ukraine, cyber attack against Ukraine began even before the use of kinetic weapons during the mass protest in late 2013. In total, the full-scale armed invasion phase, 415 cyber incidents were recorded and processed directly by security analysts registered in 2022, which is 2.8 times more than in 2021. Compared to 2021, the number of information security events increased in the category malicious software code by 18.3 times, in the category information gathering by and interrupted by 2.2 times. The number of critical IS events origination from Russian IP addresses increased by 26% compared to the same time period in 2021. Based on the results of automatically determining geolocation of IP address of source of critical events. Also, this does not necessarily mean the attribution to identified location. Next slide, please. The dynamics of cyber attacks by the Russian Federation against Ukraine can also be tracked as the analysis of status from the Office of the Prosecutor General. Given that cyber attacks are mostly qualified as criminal offenses in the field of the use of electronic computer system and computer networks and telecommunication networks, Section 16 of the Criminal Code of Ukraine. Next time. The purpose of this study is to determine the criteria for classifying cyber attacks as war crimes and the possibility of bringing the preparators to criminal responsibility, as well as to formulate the main needs of the national criminal procedure in the context of effective investigation to such crimes. Microsoft interim report at April 2022 states that the company security terms identified in the following hackers groups affiliated with the Russian Special Service has been involved in cyber attacks against Ukraine in 2022. A group of the General Staff of the Russian Armed Forces, United 26 165 PT, and another. The representatives of these groups are not combatants and are civilians, given the negative definition of civilian in Article 15 in the IACS. In particular, they belong to the non-conventional category and unlawful combatants due to their unlawful participation in hostilities. Article 45 of the IACS. And therefore may be prosecuted for crimes under Title 16 of the Criminal Code. The sporadic or constant direct participation of such persons in hostilities, performance of permanent combatant functions leads to the loss of protection from direct attack against them, but does not turn them into combatants and accordingly does not exempt them from criminal liability for military activities. Next, please. A few words qualification of cyber attacks as war crimes. Direct participation in hostilities is defined as specific hostile acts committed by individuals within the framework to hostilities between parties to an armed conflict. Under the auspices of the ICRC, the specific hostile action must meet the following cumulative features. First, the act must have a high probability of adversely affecting the military operations or military capabilities of a party of the armed conflict, or an alternative, or causing death, injury, or destruction to person or objects protected from the direct attacks of harm. Second, there must be direct causal link between the act and the harm, which may as a result of the act or as a result of a coordinated military operation of which the act is an integral part, direct causation. Third, the act must be specifically designed to achieve the established source of form and be committed in support on the party of the conflict and to the determinant of the other connection with the belligerent. It is important to ensure that such events are structured, not isolated by individual episodes of areas, which indicates that pre-trial investigation of cyber attacks related to armed conflict should be carried out, taking into account all areas and means methods of damage that be directed at particular sector of the economy of vital function within the framework to the so-called main cases, which are the national Ukraine equivalent of structural investigation. To qualify particularity still its evaluation of the laws and customs of war. It seems that one example of such violations of the laws and customs of war is the mixed kinetic and cyber attacks was carried out in 2022 and early 2023 against energy infrastructure facilities. Institutionalization of electronic evidence in criminal procedure in Ukraine. Fixation as separate type of evidence. Next, introduction of new security measures. Adoption legislation to international and foreign standards for the treatment. Determination the order of collection and storage. Institutionalization of electronic evidence in criminal procedure in Ukraine. The current legislation of Ukraine establishes only the general principle of the use of electronic evidence, the procedure for its collection and methods of research in electronic form, and therefore, in particular, many questions are regarding their use. The inconsistency of the current criminal procedure legislation with the needs of today can be traced in particular to the law efficiency of the investigation of crimes committed in the field of the use electronic computers, systems, and computer networks, and the telecommunication networks. The statistics show that on average, it's only 15% of cases that pre-trial investigation body identify the person who committed the criminal offense and notify him on her suspicion. In addition, information on cyberattacks that expressed the armed aggression against Ukraine 2014. President accompanied the full-scale armed invasion of Russia in 2024 is important for the investigation of the crime of aggression under Article 437 of the Criminal Code of Ukraine, as is allowed to more fully clarify both the scale of planning, the persons involved with the damage caused by such aggression, and another. Next slide, please. Fewer words modesty the worst electronic evidence that is collected and searched. Second, various of the types of coercive measures and needed, including measures to locate and identify internet users, that date preservation orders, production orders, decryption orders, real-time interception of data and communication, technical surveillance, and other covert measures that make online investigation possible. The demand for new measures, together with the emphasis on this rights of individual, has resulted in significant increases in the volume and complexity of regulation on coercive measures. Next slide, please. In conclusion, the nature of Congress of the cyber activities, cyber operations, the context of their use allow in to be considered as generous method means of conducting armed conflict. This stand gives grounds for the defense in criminal procedure for criminal offense under Section 16 of the Criminal Code of Ukraine in relation to such activities conducted by combatants to raise the issue of applying the Institute of Combatant Privilege, or such activities in case of serious violation of IHL should be qualified under Articles 438 in the Criminal Code of Ukraine under Article 8 of the ICCRS. Thank you for attention. Goodbye.